will sentence you to 30 years in the prison, give you credit for any time served. There's an affirmative finding of family violence, affirmative finding of deadly weapon.
Judge Boyd told this Spanish man that he will face 5 to 99 years in prison for horrible crime he had done in his family, and also he get kicked out from U.S.
Court is calling 2023 CR 7943, State of Texas versus Armando Regalado. Can I have parties announced for the record for the state?
Humberto Saldaña for Armando Regalado.
Excuse me. Y'all need to move to the other end if you want to talk in the box while we're on the record. All right. And are you Armando Regalado?
Sí.
Yes. All right. We have an interpreter here. If you could raise your right hand. Do you solemnly swear or affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand. Mr. Saldaña, do you speak Spanish?
I do, Your Honor.
And do you speak it fluently?
I do.
And were you able to communicate with your client in Spanish?
I was.
And were you able to go over the entirety of the documents with your client in Spanish?
Yes, Your Honor. Sí.
Yes.
Okay. And did your attorney go over this with you in Spanish?
Sí.
Yes.
All right. Counsel, have you received all the discovery and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Regalado, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Sí.
Yes.
Counsel, do you waive the reading of the indictment?
We do so well.
Did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Did you understand you're charged with murder? That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Sí.
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Sí.
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Sí.
Yes.
Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Sí.
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes to both, Your Honor.
Mr. Regalado, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
No.
Anyone promised you anything other than the plea?
No.
No.
Are you satisfied with the way you've been represented?
Sí.
Yes.
Are you a U.S. citizen?
No.
No.
Counsel, did you advise your client of the consequences of entering a plea in this case and its impact on his immigration status?
I did, Your Honor.
Did that advice include possible consequences such as deportation, exclusion into the United States, or denial of naturalization?
Yes, Your Honor.
And do you believe he understands the immigration consequences of entering into a plea bargain agreement in this case?
I do, and we specifically spoke about that.
Mr. Regalado, Did your attorney explain to you the consequences of entering into a plea in this case and its impact on your immigration status?
Yes.
Did you understand that potentially you could be excluded from entry into the United States
Yes.
and the denial of naturalization
Yes.
and the denial of citizenship?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. According to the plea bargaining agreement, punishment is to be assessed at 30 years in the prison. There's a $1,500 fine. No applications. You're not eligible for an application on murder. There's an affirmative finding of family violence. There's to be no contact with Francisco Nahara. Did you understand that to be the plea?
Yes.
Defense?
Yes, Your Honor.
State?
Judge, I believe it's the family of.
The family of Francisco Nahara. Did you understand that to be the plea?
Yes.
Yes.
Thank you. And did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counselor, are there any such motions?
No.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
State offers it's a good one.
No.
Did you review the document entitled Waivering Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. Court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Off the record for a moment. Counsel, I realize that you have someone who's going to want to do impact.
That's correct, Judge. She's available tomorrow.
All right, so I can sentence him today, and I can have him come back over tomorrow.
Yes.
Is everyone okay with that?
That's all right, Judge.
All right, so we'll recall him for tomorrow, Ms. Ferguson. All right, any objections to proceeding with sentencing?
No objection, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we would just hope that you would follow the agreement that we have with the state.
All right. Court will sentence you to 30 years in the prison, give you credit for any time served. There's an affirmative finding of family violence, affirmative finding of deadly weapon. There's to be no contact with the family of Francisco Nahara. There's a $1,500 fine, time and money to run concurrently. And there's to be no entry into the US unless legal.
Yes.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, thank you. All right, we'll go off the record. State, if there's no objection from the defense, if your witness would like to appear by Zoom instead of in person at the court, I know parking is at a premium. They're more than welcome to do that if the defense has no objection.
Judge, but they should prefer to be here to do it.
Okay, all right. And Norma, if you'll make sure there's a hold on him and we'll bring him over tomorrow. All right, thank you so much. Good seeing you.
My pleasure. May I be excused, Your Honor?
Yes.
A man walks into a Texas courtroom with a translator by his side, ready to plead no contest to a murder charge. This defendant, Armando Regalado, is facing a first-degree felony with a possible sentence of 5 to 99 years. After going through the standard legal checklist with his attorney, which included confirming he understood his rights and the devastating immigration consequences he now faces, he stood before Judge Boyd. In a somewhat unusual turn, the victim's family was present and ready to give an impact statement. However, the judge decided to split the proceedings, finding him guilty today, but delaying the emotional victim impact statements until tomorrow. For now, Judge Boyd handed down the agreed-upon sentence of 30 years in prison, a fine, and a strict no-contact order with the victim's family. A tense moment, but the final emotional weight is yet to come.
I am, Judge.
Okay. All right, court is calling 2022 CR 5306, State of Texas versus Mary Luella Shepard. Could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense.
Matters for the defendant.
And are you Ms. Shepard?
Yes, I am.
Going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, I did.
Are you the same Mary Luella Shepard who was placed on deferred adjudication in 2022 CR 5306 for the offense of unauthorized use of a vehicle on August 30th, 2022 for a term of 2 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 4 in Bexar County, Texas. The defendant, Mary Luella Shepard, did then and there fail to report to the supervision officer as directed for the months of September, October, November, and December 2022 in violation of condition number 4.
How do you plead to that? True or not true?
Not true.
State.
Violated condition number 1 on or about the 14th day of October 2022.
I'm sorry, I don't have a supplemental.
Sorry, it's in the supplemental.
All right, did you review the document entitled Supplemental Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, I did.
All right, you may proceed.
Violated condition number 1 on or about the 14th day of October 2022 in Bexar County, Texas. The defendant, Mary Luella Shepard, committed the offense of theft, $100 to less than $750 in violation of condition number 1.
How do you plead to that? True or not true?
True.
And Your Honor, we waive the other violations alleged in the motions.
Any objection? All right, did you understand by pleading true to violation of conditions 4 and 1, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, I do.
Knowing that, do you still wish to plead true to violations 4 and 1?
Yes, I will.
Court will find 4 and 1 true. Is there a proposed agreement?
There is, Your Honor, we're asking that you deny the motion to be the defendant on probation and extend probation for 1 year. We're asking that she can sign her conditions of probation in court today and follow the recommendations of the TAP evaluation, which are to provide proof of completion of the Haven for Hope's integrated treatment program and the outpatient treatment program with BCC SCD with monthly urinalysis and documented sober support meetings. And also the state is going to TIC County Court number 11, cause number CC 711696.
All right, is this, you're asking the court to follow this?
Yes, Your Honor.
Probation?
Sorry, Judge.
Yes.
Also, no contact with HEB at 4100 South New Braunfels.
Probation?
Yes, Your Honor. Ms. Shepard did not show for her initial intake for her original term of probation. So we would ask that we extend for the 1 year to take account of that and then follow all of the TAP recommendations.
All right. Does your client have any mental health issues?
I don't believe so, Judge.
So why should I not just revoke her? She didn't show up, she didn't do anything. She disappeared and all she did was pick up a new offense. So why shouldn't she be revoked? She can find her way to the HEB. I know she could have found her way to probation. So why should I give her another chance? She hasn't done anything except picked up a new case.
I believe she will follow the recommendations of probation at this point, Your Honor.
All right, the court is going to grant the motion, find you guilty. Does anyone want to speak to a sentence?
Judge, we had talked about if, she wasn't gonna do treatment, something on the shorter end, Judge, so, I'd leave it up to the court's discretion, but if she wasn't gonna seek treatment, we talked about, something, on the lower end of the scale, Judge.
I'll sentence her under 1244. And I'll sentence her to 200 days at the Bear County Jail. Is there anything else? And the court will take in consideration 711696 and give you credit for any time served. Going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right, you have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
I understand.
All right, we can go off the record. Ms. Shepard, I want to let you know, I did listen to the recommendations from the state and the agreement that was made,
Yes, ma'am.
but you haven't done anything. You didn't report, you didn't do anything.
I understand.
All right. Okay, good luck to you, okay?
Thank you.
You're welcome.
Mary Luella Shepard thought she could ghost her probation officer and get away with it. She was wrong. This case is about a defendant who was given a sweetheart deal, 2 years of deferred adjudication for stealing a car, but decided to go completely off the grid. She didn't report for months. And to top it off, she picked up a brand new theft charge while she was supposed to be on her best behavior. Judge Boyd looked at this record and wasn't impressed. The defense asked for another chance, promising she'd follow the rules this time, but Judge Boyd cut through the excuses, pointing out the obvious. She found a way to commit another crime, but not to her probation officer. In the end, the judge revoked her probation, found her guilty, and handed down 200 days in the county jail, a classic case of wasting a second chance.